Judicial review. The kind of judicial review originated developed by USA. It was propounder of the first time famous Marbury and Madison case, then Chief Justice of American Supreme Court. In India, other hand, the Constitution itself conferred the power of judicial review. Further, the Supreme Court has declared the power of judicial review as a basic feature, element of basic structure of Constitution. Hence, the power of judicial review cannot be curtailed. The meaning of judicial review. Judicial review is the power of jurisdiction to examine the constitutionality of enactment of the orders. On examination, if they are found violate the Constitution, they can declare illegal and unconstitutional by the judiciary. Consequently, they cannot be enforced by the government. Judicial review of the Constitution Amendment, judicial review of the legislation of the Parliament, and judicial review of the administration action of the Union and the State. Supreme Court used the power of judicial review various cases. Golaknath case, 1967 bank nationalization, Privy Purse case, Keshwanand Bharti, Minerva Mill. Supreme Court declared the 99 Amendment and the National Judicial Appointment Commission Act as a null and void. Importance of judicial review to uphold the principle of supremacy to maintain the federal equilibrium, protect the fundamental rights. In the other hand, Supreme Court has pointed out the significance of power of judicial review in our country. Some are in India. It's constant that supreme and the statute of law to be valid must be conformatory with the Constitution required, and it is for our Constitution contain the express the provision of the provision for the judicial review of the legislation. This is especially true regard the fundamental rights, and as long some fundamental rights exist are part of the Constitution, the power of judicial review is also exercised with the review the afford rights. The Constitution supreme, the permanent law of the land, and there is no branch of government. Every organ of government, be it the executive or the legislative, derived from the Constitution, it has to act within the limits of authority. No one, however highly placed, the judges of the extent of power under the Constitution or whether it is action within the confine. Court is the ultimate interpreter of the Constitution. Court is assigned the dedicated determining what is power confirmed. It is the function of the judges may their duty and pronounce the validity of the law. If court are totally deprived, the fundamental rights conferred with become mere adornment because of rights without remedy are writ is rotter. A control constant with then becoming uncontrolled. The judges of Supreme Court have been entrusted with the task of upholding the Constitution, has been conferred the power to interpret it. Constitution is maintained and then legislation and executive in discharge of their functions and the transgress the functions. The founding father very wisely therefore incorporated the provision of judicial review so maintain the balance of federalism, fundamental right and freedom, and enjoy the equality, liberty, and the function of judicial review is the part of the interpretation. The Constitution provision for the judicial review. Article 13 declared that all laws of the incorporation derogation of fundamental right. If there is derogation, then it will be null and void. 32 guarantees the right to move to the Supreme Court enforcement of the writ. 131 provides the original jurisdiction for Supreme Court. 132 provide for the appellate jurisdiction. 133 provide for the appellate jurisdiction of the Supreme Court in civil cases. 134 for the criminal cases. 134A deal with the certificate the appeal for Supreme Court in a High Court. 135 empower the Supreme Court to exercise the jurisdiction the Federal Court. 136 authorize the Supreme Court to generate the special leave. 143 authorize the President seeks the Supreme Court for the advisory opinion. Empower the High Court to issue the direction and order for the High Court fundamental right. 227 gives the High Court the power of superintendent or all courts for tribunals. 245 deal with the territorial extent of the law of Parliament. 246 deal with the subject matter of the Parliament under the legislature, union, state and the concurrent list. 251 and 254 provide that cases of conflict between the central law and the state law. 372 deal with the continuance or the pre-continuance of the law. Scope of judicial review: it is infringe the fundamental right, it is outside the competence authority, and it is repugnant with the constitutional provision. It is clear that the scope of judicial review is the narrower. The America does not explicitly mention the concept of judicial review. This is because American Constitution provides for due process of law. So there is a due process of law against the procedure established by the law, which is contained in the Indian Constitution, and the difference between two. Due process of law gives a wide scope of the Supreme Court to grant the protection. It can be declared law violative of this void not only substantive ground but also procedural ground. The exercise of wide power of judicial review of American Supreme Court in name of the due process of law clause met the critics. Third chamber of the legislation is super legislature, the arbiter of the social policy, and so this American principle of judicial supremacy is also recognizing constitutional system but the limited extent. Principle of parliamentary supremacy: many limitations of sovereignty of the parliament, written character of the constitution, federalism, division of power, fundamental rights. In effect, they exist. India has a synthesized both that American and British parliamentary supremacy. Judicial review of the 9th schedule. Article 31B. Save Act regulation included 9th schedule challenge in the ground of contravention of the any fundamental right. Article 31B along with the 9th schedule, first constitutional amendment. The 9th schedule contains 13 acts and presently 282 of act. Regulation of the state relation deal with land and reform, abolition of jamidari. In the significant Kovalo case, Supreme Court ruled that could not be blanket immunity from the judicial review. 9th schedule. The court held that judicial review is a basic feature. This is a basic feature. 9th schedule. It is law plays the 9th schedule, and if violated the fundamental rights of the basic structure. While delivering the above judgment, a law of the prerogative abridged the rights guaranteed by Part 3rd as a basic structure. Article of Part 3rd: by the insertion of 9th schedule, such law will have to be invalidated of judicial review. The constitution validity of 9th schedule law on the touchstone for the basic structure, which means amendment is not the relevant. The majority judgment of Keshwan and Bharti case, read the Indira Gandhi case, required the validity of each new constitutional amendment. Part 3rd has to be taken into account determining whether or not destroy the basic structure. All the amendment of 24 April 1973 9th schedule is amended inclusion of various law. So article 14, 19 and the principle underlining is there. The first amendment 1951 and the jurisdiction for the conferring protection of the constitution